A very warm welcome to my YouTube channel. Myself, Maninderjeet Kaur Boparai. Today I am going to discuss a very important judgment of the Criminal Procedure Code, that is Lalita Kumari versus Government of Uttar Pradesh. Its year was 2014. This was delivered by the Supreme Court of India. There were total 5 judges involved in this case. The judgment was given by 5 judges of the Supreme Court. First one is Justice P. Sathasivam, Justice B. S. Chauhan, Justice Ranjana Prakash Desai, Justice Ranjan Gogoi, and Justice S. A. Bobde. As you all know, this is a very important judgment of the CRPC. So, the brief facts of the case are: a written petition under Article 32 of the Indian Constitution has been filed by Lalita Kumari, a minor, through her father Shri Bhola Kamat for issuance of a writ of habeas corpus or directions of the same kind against the respondent, herein for the protection of his minor daughter who has been kidnapped. The grievance in that writ petition is that on 11th May 2008, the complainant sent a written report before the officer in charge of the police station concerned, who did not take any action on the same matter. That is, he has not registered an FIR in this case. After that, when the superintendent of the police was transferred, this FIR was registered. According to the complainant, no action was taken either to prosecute the perpetrator or to rescue the minor child. So, these were the basic facts of this case. Now, I'm going to discuss issues involved in this case. There were total 2 legal issues raised in this case. That first one is whether a police officer is bound to register a first information report, that is FIR, upon receiving any information relating to the commission of a cognizable offense under section 154 of the Code of Criminal Procedure 1973. Whether the police second issue was whether the police officer has the power to conduct a preliminary inquiry in order to test the veracity of such information before registering the same. That means there were 2 main issues. Now, the petitioner's contention was that the petitioner's counsel stated to the court that since a complaint is received by the officer in charge of the police department, he must record the FIR under section 154 of the Code of Criminal Procedure. The reliance was put on the judgment of the Pex Court like State of Haryana versus Bhajanlal, Ramesh Kumari versus State and City of Delhi, Prakash Singh Badal versus State of Punjab. The petitioner later on draws the court's attention to the fact that, according to section 154, subsection 1 of the code, the term shall is used by the legislation. He also said that it is necessary for the police officer to file the FIR. He claimed that, according to section 154 of the code, there are no implied provisions relating to the preliminary inquiry. Thus, there is no discretion left to the police officer. In this aspect, reliance was placed upon the certain cases. First one is B. Premanand versus Mohan Koikal, Hira Lal Ratanlal versus State of UP, Gobind Lal Chagan Patel versus Agriculture Produce Market Committee, Godra. Lastly, the petitioner also contended that Section 154, subsection 1, refers to the term information without prefixing the word reasonable or credible, which means that the authenticity or credibility of the information is not a precedent for the registration of the event. In response to petitioner's contentions, the respondents' counsel argued that the registration of the FIR cannot be subject to a structural formula since it is an administrative action involving the operation of the mind, scrutiny, and the verification of the evidence. No regulatory act can ever be mechanical. The respondent put reliance on four cases. First one is Rajinder Singh Katoch case. Secondly, P. Sirajuddin versus State of Madras. Thirdly, State of UP versus Bhagwant Kishore Joshi. And fourthly, Savi versus State of Tamil Nadu. In this reference, the respondent contended that prior to the registration of the FIR pursuant to section 154 of the code, it is available to the police officer to conduct a preliminary investigation to determine whether or not there is a prima facie case of commission of a cognizable offense. The learned counsel further argued that a statute should not be read in such a way as to result in a lack of discretion on the part of the police officer, particularly in fake cases where the registration of the FIR leads to an empty formality. Furthermore, it was asserted that any law should be read in the light of Article 19, Article 14, and Article 21 of the Constitution, which provides for the protection of an innocent person from false charges. In cases such as this, a police officer must be equipped with the power to perform a preliminary investigation. So, these were the contentions raised by the petitioner as well as by the respondent. In the last judgment, the Honorable Supreme Court has given its valuable views. The Honorable Apex Court, in view of the same, stated that first of all, it is mandatory to file the FIR under Section 154 of the Code if the information discloses the commission of a cognizable crime, and no preliminary investigation is permissible in such a case. Secondly, if the information does not reveal a cognizable offense but suggests the need of an investigation, a formal investigation will be undertaken. Thirdly, if the investigation reveals a cognizable offense, the FIR must be reported. If this is not the case, a copy of the entry of the closure must be sent to the first informant immediately and no longer than 1 week. Exceptions under which preliminary inquiry can be made before registration of FIR are: first one is matrimonial disputes or family disputes, secondly, commercial offenses, thirdly, medical negligence cases, fourthly, corruption cases, and the lastly, cases where there is an abnormal delay in initiating criminal prosecution. In these cases, preliminary inquiry can be made before registration of FIR. So, this list of cases, this list of cases which was given by the Supreme Court for doing preliminary inquiry before registration of a FIR is only illustrative and not exhaustive. Lastly, in the conclusion of the preliminary investigation, The Supreme Court held that the conclusion of the preliminary investigation shall not exceed 7 days, and all records relating thereto shall be reported in a general diary, which shall be kept in the police station. So, this was the decision given by the Honorable Supreme Court. I hope you enjoyed this video and gained some knowledge. Kindly like and share my YouTube channel, and also subscribe the bell icon for further videos. Thank you so much.